This lesson will cover the Georgia statutes and regulations governing timeshare programs. A timeshare program refers to an agreement for the use, occupancy, or possession of real property where the property is divided into predetermined and recurring time periods. The buyers may divide the property access on either a fixed or floating schedule, as long as the timing occurs annually and the time period is over 1 year in duration. For example, 6 co-owners of a single condominium unit may share a property based on each owner having access and full use to the property twice each year for a calendar month each stay. The timeshare program can be created as either a fee simple estate or a use arrangement, leasehold. An estate in fee simple is an absolute ownership characteristic where there are no restrictions on use or tenancy other than those issued by the government. A leasehold arrangement is considered to be an ownership defined in years, such as a 99-year lease that either expired or may revert to prior owners, or be renewed by a new contract. The Georgia Timeshare Act, adopted in 1983, governs timeshare programs in the state of Georgia. The act was amended in 1995. Provisions of this act, and any amendments, apply to all timeshare programs within Georgia state boundaries, and any out-of-state programs sold within Georgia. The act allows timeshare buyers the same privilege afforded to condominium buyers: the right to rescind a contract to purchase within 7 days of entering into a contract. A timeshare program developer creates a timeshare program by filing a set of required documents with the Superior Court of the county or counties where the proposed program will be located. The initial document package must include county name or names, a legal description or other description that completely identifies the property, identification of timeshare estates, and the method for creating future estates, if applicable, the method used to calculate common expenses, voting rights assigned to each divided interest, and any units in a development not assigned to the timeshare program, restrictions on use, occupancy, modification, and alienation of timeshare intervals, owner interest, if applicable, personal property contained on the property, and provisions for repair and maintenance, and the reasonable arrangement for managing common areas, units, and property repair and maintenance, including unit furnishings. This is similar to requirements for condominium projects, in that owners share benefits and responsibility for areas not necessarily contained within an individual dwelling. Developers have certain responsibilities to prospective buyers. The Georgia Timeshare Act requires developers to provide written documentation that describes the property care and maintenance plan, and they must only use licensed real estate agents to make the program and negotiate contracts. Developers must also make sure any marketing promotions and/or contests comply with the Fair Business Practices Act as administered by the Office of Consumer Affairs. The Timeshare Act has other buyer protections, such as a provision that prohibits any person from charging an advanced fee when helping an owner resell a timeshare interval. Advertising fees must be paid to a non-affiliated third party, not the agent brokering the sale. In other words, a real estate agent could not ask for money up front to run newspaper ads or create a social media ad, but an owner could run an ad in the local newspaper himself, providing he pays the media company directly. The Act also stipulates that timeshare documents must create an association of timeshare unit owners to manage and operate the program. The association must create bylaws, arrange for a program manager, establish and collect assessments to cover repair and maintenance, insurance, and other shared operating expenses.